Hello and welcome to the e-Pathshala course on intellectual property rights. I am Yogesh Pai, Assistant Professor of Law at National Law University, Delhi. We are going to discuss a module on exhaustion of intellectual property rights. Let me provide you a brief outline of the whole module that we are going to discuss in this brief 35 minutes. So we'll start with the premise that property law envisages in relation to sale and what does it mean to impose absolute conditions on sale, what it means to have first sale doctrine in intellectual property law, different kinds of intellectual property involving patents, copyrights and trademarks, whether there are any exceptions to first sale, and what would it mean to have a regime of exhaustion, either national, regional or international. We'll also discuss arguments both for and against international exhaustion. We'll discuss some of the issues surrounding the TRIPS agreement in relation to Article 6 and the principle of exhaustion that countries can follow within their domestic laws, whether TRIPS does or kind of envisage any particular kind of exhaustion or not, and what are its relationship with dispute settlement will be discussed in this particular slide. We'll also discuss exhaustion of patent rights in India, exhaustion of copyrights in India, exhaustion of trademarks in India, followed with a specific discussion on exhaustion of self-replicating technologies. We'll look into the Baumann versus Monsanto decision delivered by the Supreme Court of United States a couple of years back. We'll also discuss exhaustion of copyright infringing products, where the object of the sale of the product or importation of the product into India is necessarily not the copyrightable work itself. So in relation to ancillary works, how does copyright law envisage exhaustion will be discussed in this module. Finally, we'll end up with a brief summary of issues that we have discussed and kind of conclude with some understanding of the regime of exhaustion and the future of exhaustion in India. One of the important principles in relation to the sale of property is that the property vendor may not impose any absolute condition on sale that defeats the very purpose of deriving value from such property, either in land or in chattels. This principle has its basis in the fundamental fact that any such absolute condition on further reselling the product will not help the buyer in actually realizing the value of the property. If you look into the rights that are granted to property owners, primarily they include a right to use and exclude the property and to convey the property. Hence, any such conditions on conveying the property will kind of impose absolute restriction on the ability of any buyer to enjoy the property in its fullest sense. Now, this principle has been extended in relation to IP, which is called as the first sale doctrine, which means that any kind of argument in relation to first sale would involve a situation where the buyer of a product in which there is some kind of IP embedded, either in the form of patent, copyright or a trademark, has absolute right in terms of further selling or reselling the product, and the IP holder loses his ability to pursue such product. This particular principle of first sale derives its basis from property principles, as in land and chattels, and it primarily includes a situation where the buyer of any IP protected product can further sell it. However, the IP first sale doctrine applies in relation to the exact copy of the product that is sold to him, and he may not replicate further products or distribute them without the permission of the intellectual property holder. So the first sale doctrine, it's clear, only applies to that particular product which has been sold and not to any other product that he may make copies, because that would directly conflict the right of reproduction and other kinds of distribution rights involving the IP rights holder. However, there are certain notable exceptions to first sale. One of those exceptions is that in relation to a computer program or a sound recording or a cinematographic film, the first sale doctrine shall not apply. And this is very clear from one of the decisions of the Delhi High Court in Santosh VG, where the defendant was running some kind of a video parlor or rental service, and the defendant was renting out his CDs and DVDs, and which were lawfully sold in United States and Canada. The defendant used to import those CDs and sell them here for a rental fee. Now, in this case, the plaintiff, which was a leading film production company, in the United States filed a case alleging that defendant in India had no rental licenses in his favor, and that all acts of rental would amount to a copyright infringement under section 14 clause D clause 2 read with section 51 of the act, which deals with infringement. Now the contention of the defendant was that all of its CDs and DVDs were legally authorized to be sold within USA, and hence the first sale doctrine would apply. Now the court said that this first sale doctrine, which is allowed under section 14D read with clause 2M, incorporates a principle of first sale doctrine. However, it does not apply to classes of works which are not mentioned in that particular clause. So section 14, the court took note of section 14 and said that copies not already in circulation would definitely mean that there is a first sale doctrine. However, such in case of cinematographic film, making unauthorized copy of the film or selling it for hire would mean that would amount to an infringement, and hence specifically in the context of cinematographic film, where there is a clear rental right enshrined in the act, the first sale doctrine would not apply. Now, apart from these notable exceptions to first sale in situations like computer programs and cinematographic films and sound recordings, we understand that this obligation is also there in the TRIPS agreement, article 12, which talks about rental rights in relation to computer programs in cinematographic films and sound recordings, but it is left to member countries to decide only where there is certain amount of damage that is occurring to the right holder. Now India has exercised this particular right in favor of IP holders, and clearly provides that fair use doctrine may not prevail, and this VG Santosh decision decided by the Delhi High Court in 2009 is pretty much clear. Now there are certain principles of first sale when applied to national, it's called as a national exhaustion, and when applied when there is a first sale internationally, it's called as international exhaustion. By this we mean that in a situation where there is national exhaustion and or countries that follow national exhaustion, any importation of IP protected product elsewhere would amount to an infringement of a territorial right. It means first sale doctrine is territorial in nature, and that the defendant, the importer, may not rely on the fact that there was a valid sale outside the particular territory. Now this is the case of national exhaustion. In case of international exhaustion, any first sale outside the particular territory or any part of the world would exhaust the right of the intellectual property holder, and hence by virtue of this, parallel importation of the IP protected product would be allowed. Now there are certain arguments both in favor and against international exhaustion. The arguments against international exhaustion primarily are owing to the fact that IP owners would be specifically discouraged from price discrimination and segmenting the markets. So it would mean that all those products which where there would be a price arbitrage, IP protected IP owners would be restrained from price discriminating, because they are not encouraged to do this by virtue of international exhaustion. Similarly, there is a worry that any kind of price discrimination may discourage IP owners to take measures that relate to kind of advertising, or those that involve specific local vendors where they invest quite a lot in the sale. So these there are free riding effects of international exhaustion, and those need to be taken care of. But otherwise, there are specific positives and specific advantages of having an international exhaustion regime, especially for a developing country like India, wherein you can have access to the cheapest material that is derived through first sale in any part of the world. Now TRIPS agreement has nothing much to say about the regime of exhaustion that countries can follow, except that Article 6 says that in relation to any regime of exhaustion that countries might want to follow, Article 3, that is national treatment, and Article 4, that is MFN, shall be followed. Primarily it means that you may have national or international exhaustion, however you shall not discriminate between nationals, and if you provide a particular regime of exhaustion to one particular member, then that particular regime of exhaustion shall be extended immediately and unconditionally to all members of the WTO. Now, there is a kind of argument whether certain provisions of Indian Patent Act in relation to exhaustion would violate the TRIPS agreement, primarily because of the fact that since exhaustion is not defined, and if it runs contrary to the right of importation, distribution, and other kinds of rights that are clearly envisaged in the TRIPS agreement, whether there would be any kind of such violation. Let's look into the Patents Act for a moment and see how the regime of exhaustion is designed in patent law. Section 107 clause A of the Patents Act says certain acts not to be considered as infringement. For the purposes of this act, the importation of patented products by any person from a person who is duly authorized under the law to produce and sell or distribute the product shall not constitute an infringement. Now, by virtue of this provision, it allows any price arbitrage of a product that does not have a first sale in any part of the world, in the sense that for a first sale doctrine to kick off, it has to be sold by the IP owner. But in this case, in the Indian case, by virtue of who is duly authorized under law to produce, would mean that it could be any person other than the IP holder who makes a first sale, and hence there is a question whether such kind of importation into India would violate section 48 of the Patents Act. Now, this becomes also TRIPS contentious because certain rights that are granted under Article 28 may run primarily contrary to the exhaustion regime that is enshrined in section 107 clause A, B of the Act. So this particular provision is highly TRIPS contentious in the sense that who is duly authorized under law, if it has to include any other person than the IP right holder, and by virtue of a first sale from such other person who is duly authorized in law in a particular country, and such products, if they are imported into the territory of India, may violate section 48 of the Act, which is in turn reflective of the provisions of Article 28, which lays down the rights of the patent holder. Now, there is some contention as to whether India's regime of exhaustion is unique, or whether India's regime of exhaustion is actually what is primarily enshrined in comparative jurisdictions in other countries, including the TRIPS agreement.